desk can pass your messages directly to your audience in Geneva, whether they like it or not. I just like to take this opportunity to quickly thank our sponsors. Number one, the support of the Brazilian Embassy for this event, and of course of the Woodrow Wilson Center for hosting us, and has also collaborated with the organization. And I would like also to mention the Brazil-U.S. Business Council, who also gave us support for this event, and of course the legal advisors for the ABCI Institute, Arnold and Porter, LLP, and our sponsors. I would like to thank are the following: Castro Barros Sobral Gomes Advogados, a Brazilian law firm; Felsberg and Associados; Greenberg Trarig from this town; Matos Muriel Kartzner Advogados; Sidley Austin LLP; and Veirano Advogados. I see here a large majority of Brazilian firms. Who knows? Maybe next year U.S. firms will tie the score. This event, you can put on your calendars, happens every Friday of Carnival. It doesn't matter what date that is. It's simply a date that we came to agree with because it's the easiest time for Brazilian professionals to leave the country. While the tourists are coming in, Brazilians leave. But anyways, I just wanted to give you that message, and I like to remind everyone that the bios for all the speakers on this panel are in your program, so we're not going to waste too much time. They're very well known to all the crowd in here that I can see. They're all specialists in the matter. I will start by asking Flávio Marega, the head of the dispute settlement department at the Brazilian Foreign Ministry, to start the panel going. Flávio.
Thank you very much, Aluísio. I would like to congratulate ABCI Institute and Woodrow Wilson Center for organizing this symposium. I've participated in the 3 symposiums so far, in the last 2 events as a panelist. And so I'd like also to thank for the invitation. I always like to tell a little story when we talk about compliance issues that I experienced when I was posted here at the Brazilian Embassy in Washington, D.C. as Trade Policy Desk. I went to a seminar in Washington, D.C., which at the time was discussing the Byrd Amendment dispute in the WTO. The result of the dispute had not come to public yet. And in the discussion, there was one representative of the U.S. Congress, actually one aide to Senator Byrd, who defended very vigorously the legislation. So at the end of the seminar, I approached her and said, I would like to have your talking points. You have a very interesting point regarding the Byrd Amendment. Brazil has been affected by this measure, as you know. And she said to me, well, you have to understand, if the WTO rules against us, we're not going to comply because it's our law. So I asked myself, if each and every member of the WTO decides not to comply because that means a change in their legislation, what is the meaning of the WTO? We could simply, perhaps close the headquarters at Rue de Lausanne in Geneva and go back to the 30s after the Great Depression, when the world faced a big protectionist mood. To start with the issue we are discussing today, after the recent decision adopted by the appellate body that has already been mentioned by Dan this morning, with regard to the dispute U.S. measures relating to zeroing and sunset reviews taken by Japan to the WTO, the Washington Trade Daily informed that 2 Democratic lawmakers have asked the administration to delay acting on World Trade Organization dispute settlement body rulings against the U.S. zeroing methodology. And according still to the Washington Trade Daily, Senate Finance Committee Chairman Max Baucus and House Ways and Means Chairman Charles Rangel called the rulings questionable, saying that the panels appear to be trying to impose commitments on the United States that it never agreed to take. By contrast, if we take the recent book, Jim Baucus, I have the honor and the privilege to share this panel with him, his book called Trade and Freedom, we find there a very different view of an American about the WTO dispute settlement system, probably due to the fact that Jim Baucus was a member of the appellate body for 8 years and, in my view, understands very well not only the importance of the WTO rules for the world trading system, but mostly the role the dispute settlement system plays in that multilateral organization. Quoting the former Director General of the WTO, Mike Moore, who said the dispute settlement was the crown jewel of the multilateral trading system, in his book, Jim Baucus declares that dispute settlement system must remain the crown jewel of the overall WTO trading system. After all, for what good are the rules if they're not upheld, asks Jim Baucus in his book. This question is directly related to the issues of compliance we're discussing in this panel. Professor John Jackson teaches us that the initial decision as to the modalities of implementation of a panel or the appellate body report, and thereby the decision as to how to comply with the rulings and recommendations of the DSB, belongs to the member taking those steps. So, it's up to the respondent in the WTO dispute to make appropriate measures, to bring in conformity its laws, rules and regulations with the covered agreements. But what happens when two important and prominent congressmen in the United States, the biggest trading nation in the world, try to downplay the rulings of the DSB, declaring that the WTO is creating commitments that the U.S. never agreed to take? Well, again, going to Jim Baucus and the lessons in his book, he also reminds us that the WTO dispute settlement system is unique, and the first reason why it's unique it's because it has compulsory jurisdiction. This means that all members of the WTO have agreed in the WTO treaty to use the dispute settlement system exclusively to resolve all their treaty-related issues, treaty-related disputes with the other WTO members. So, if the United States at the end of the Uruguay round has agreed with the package of the covered agreements, which includes, of course, the DSU, it is hard to understand why Senator Baucus and Representative Rangel now say that the WTO is creating commitments that the U.S. never agreed to take. On the contrary, and I don't need to remind the audience and the panel, the role that the United States played in the Uruguay round and the negotiating efforts of this country in order to have a new dispute settlement system, much stronger, with much more teeth, so to say, as we use the jargon in the WTO. In my view, the United States should be the number one to abide by WTO dispute settlement system rulings, the number one to implement the DSB decisions, the number one to show to the world that this major trading nation respects the multilateral trade rules. But unfortunately, that's not what we see happening at present and not what we saw happening in the last years. I don't want to turn my presentation into a US bashing about WTO compliance, or better saying, WTO non-compliance. But the facts speak for themselves. If we take a look at the agenda of the coming DSB next week in Geneva on February 20, under Item 1, Surveillance and Implementation of Recommendations Adopted by the DSB, we find 1. United States Section 211 Omnibus Appropriation Act of 1998, status report by the United States. This was a case brought by the EC against the US. The panel report in the appellate body conclusions were adopted on February 1st, 2002. Second item of the agenda, United States anti-dumping measures on certain hot-rolled steel products from Japan, status report by the United States. This report was adopted on August 23rd, 2001. The third case is United States, Section 110 of the U.S. Copyright Act, status report by the United States. This report was adopted even earlier on 27 July 2000. The fourth is United States laws, regulations, and methodology for calculating dumping margins, zeroing, status report by the United States. This report was adopted more recently in 9 May 2006. If we go to item 2 of the agenda of the DSB, we also see the US on the stage. United States measures relating to zeroing and sunset reviews. This is exactly the case I started my presentation with, and it's the case that very important 2 congressmen from US Congress were asking the administration to delay acting on WTO dispute settlement body ruling. But the DSB agenda continues, and the US continues to be on the stage, on the spot. Item 4 of the agenda, the Continued Dumping and Subsidy Offset Act, also known as the Byrd Amendment, as I just mentioned, implementation of the recommendations by the DSB. We know that this implementation is going to take place, if I'm not mistaken, at the beginning of September or end of September, but there we will have statements of Canada, European communities, and Japan complaining about the late implementation of this case that the US lost in the WTO. And finally, we will have another item in the agenda, which is United States subsidies on upland cotton. There, Brazil will make a statement regarding problems we had in the implementation panel that it's taking place now under Article 21.5 of the DSU. And the US, in the two occasions, presented their submissions untimely. That is, after the time was ruled by the panel. When I got my new job 1 year ago, my now boss, Minister Roberto Azevedo, who was in charge of this issue, the first advice he gave me was, we cannot lose filing in the WTO. I mean, the time frame for filing submissions is something that we cannot lose, and this is a principle we abide by very seriously in the case of Brazil. So, as we can see, the United States is involved in all non-implementation or non-compliance cases in the WTO at present, except for one, which is item 3 of the agenda of the DSB, regarding the implementation by the European communities of the recommendations and rulings in relation to the case regime for the importation, sale, and distribution of bananas. Speaking for Brazil, our recent experience acting as a complainant in the WTO and regarding complainants of WTO decisions show 2 positive results involving the European Union. The dispute European communities exports of subsidies on sugar and European communities customs classification of frozen boneless chicken cuts. In the first dispute, the European Council adopted, among others, Regulation 318/2006 on February 20, 2006, which dealt with the common organization of the markets in the sugar sector in the EC. This decision was taken well before the date established by the DSP for the EC to comply, which was May 22, 2006. The regulation, just to show the complexity of this decision and the implications for the EC, the Regulation 318/2006 sets out the framework for a comprehensive reform of the EU sugar sector that lasted for more than 40 years. So far, the reform of the European sugar regime has been monitored by the co-complainants in this case, which were Australia, Brazil, and Thailand, in order to see how the EU will respect the scheduled limits of exports of subsidized sugar bound in the WTO. We, the co-complainants, are cautiously optimistic that the new European sugar regime will result in less and less production of subsidized sugar and consequently less exports of such product up to the limits bound in the WTO. With regard to frozen boneless chicken cuts, the EC also complied with the WTO decision on the limit date established by the arbitrator, in this case, which was my colleague Jim Bacchus. And as an arbitrator, he established the date of June 26, 2006, for the EC to comply with the WTO decision. They did so. They went back to the classification that was the subject of the dispute. But unfortunately, the outcome of the case, Jim, was not exactly what Brazil had in mind, since the European Union, after complying with the WTO decision, exerted its rights under Article 28 of the GATT 1994 and rescheduled the frozen salted chicken and other chicken processed products exported by Brazil back to the tariff levels that were subject of the dispute. As a result, the EC granted a quota to Brazil and Thailand, also co-complainant in this case, under the negotiation of Article 28 of the GATT, as I just mentioned. On the one hand, if the result of the dispute was not an increase in market access to the European Union of Brazilian chicken products, as we wished, on the other hand, we cannot say that the EC was in non-compliance at the end of the reasonable period of time determined by the arbitrator Jim Bacchus. The third recent dispute in which Brazil acted as a complainant in the WTO was United States subsidies on upland cotton. As we all know, the outcome of this dispute was not satisfactory at all to Brazil. The DSB recommended that the United States withdraw 3 export credit guarantee subsidies maintained by the Commodity Credit Corporation, the CCC, that is, the GSM 102, GSM 103, and the Supplier Credit Guarantee Programs, and or otherwise bring itself into compliance with its obligations by the implementation deadline of July 1st, 2005. On this date, the U.S. announced in Geneva in the WTO that the CCC would no longer take applications for export credit guarantees under GSM 103 and amended the fee schedules for the export credit guarantees under GSM 102 and the Supplier Credit Guarantee Programs. Since July 1st, 2005, the United States has not issued any supplier credit guarantees, and since October 1st, 2005, the U.S. has not issued any SCGP's guarantees. But the GSM 102 program continues largely to be used by the CCC after the change in the fee schedules, which maintained the 1% cap. And as the GSM 102 was and still is responsible for the great majority of the export credit guarantees granted for exports of U.S. cotton, in our view, the United States is far from compliance with regard to these prohibited subsidies. With regard to actional subsidies, the counter-cyclical payments, the marketing loan, and the Step 2 program, the compliance situation by the U.S. is not better at all. It's even worse, given the magnitude of these subsidies. The DSB adopted the panel and the appellate body reports that obliged the U.S. to remove adverse effects caused by the subsidies or to withdraw such subsidies by 21 December 2005. Nothing was done in this case. The U.S. did not repeat or amend any of the 3 price contingent subsidies until August 1st, 2006, when it finally discontinued solely the Step 2 program. The result of this non-compliance issue, as I just mentioned, has taken Brazil to ask the formation of a panel under Article 21.5, which is now, at present, evaluating if the US has fully implemented the WTO decision on the subsidies for upland cotton. In the case of Brazil, and I can tell, being part of the Brazilian government, when we are respondent in a WTO case, the Brazilian government tries to make all efforts to avoid taking the trade disputes to the WTO. But if a case is taken against Brazil by another WTO member, and we eventually lose the dispute, the decision to comply is taken at the highest level by the Brazilian authorities, which involves the Chamber of Foreign Trade, CAMEX, 6 ministers that deal with foreign trade, a collegiate body that congregates all ministers related to foreign trade, as I said. And such a decision is taken as much as possible before the end of the reasonable period of time. So to end my presentation, I would like to pose a question to the audience as well as to the panel. Why is the US the bad guy in the picture when we talk about non-compliance? In the case of the European Union, we have the EC, the European Community, a supranational entity which is responsible for foreign trade in many areas, and perhaps that makes things easier in terms of compliance. In the case of the United States, we have the executive branch, the USTR, and other agencies involved with foreign trade in the one side, and the US Congress in the other. And in the middle, we have the Trade Promotion Authority. So my final question is, what can the US do to prompt comply with WTO decisions? After all, the major trading nation, as the US, should be the first one to give the example to other WTO members. Thank you very much.
Thank you, Flavio. Thank you, Flavio, for that good beginning. Apologies to the audience for my own tardiness. I had a little miscommunication about the beginning hour. We're going to continue this session hearing from Professor Velber Baral from the Federal University of Santa Catarina.
Okay, thank you. Well, I'd like to thank initially Aluísio and the ABCI and the Woodrow Wilson Center for the invitation. It's weird to thank someone who invites you to come to 10 Fahrenheit during Carnival, but it's a great opportunity, and Aluísio has been doing a great work with the ABCI team. The topic is the Brazilian experience and the compliance of WTO disputes. And I have two initial questions, which I will try to answer during these 15 minutes. First, why is Brazil a party to so many cases? Brazil has 1% of the world trade, and it is involved with 14% of all the cases at the WTO. That's a difference with Flavio's analysis, but on the other hand, is it rational to have so many cases considering the level of compliance? And I try to expose some political economy of cases in Brazil and how is it rational or not to have so many cases. In fact, there is a contradiction with a famous Brazilian historian, Caio Prado Jr., who had a thesis about the gentle Brazilians. And it's a famous thesis. He tries to expose, his thesis was that Brazilians, because of their historical and social characteristics, we had never had a civil war in Brazil, for example. All the political changes in Brazil were arranged. Our social and rational patterns would be determinant for a more tolerant attitude towards the world and towards compliance. However, in spite of this thesis, Brazil became very active at the WTO. So, of course, these statistics are relative. On one hand, because Brazil and India are so active, that is also explained because of the low level of participation of other developing countries. Meaning that the African countries, for example, basically never had a case because of some domestic constraints like costs, the capacity, the dependence of former countries, especially the European countries. These statistics are also relative because they are determined by by international trade scenario, meaning other factors like the ongoing negotiations determine more cases or less cases. This relationship was very well documented by the literature on the field. There is also reverse relationship. If there is some promises of settling disputes through negotiation, we have less cases. If these promises are reduced, more complaints are presented all over the world. In this moment, in the last 2 or 3 years, we had a reduction of cases at the WTO during this expectation about the Doha Round. Maybe if Doha doesn't have a good result by the mid of the year, the number of cases will go up. So there are some international factors, but my point is that there are other domestic factors. And Brazil is a great example of these domestic factors because of the changes that has occurred in Brazil during the recent economic history and political history. In the economic area, until the early 90s, Brazil was a very closed economy. There was a high degree of openness by early 90s, and that openness happened with an overvaluated currency. The effect of that was a flow of imports. This flow of imports provoked a reaction from the national industry, and by then there was many complaints against the Brazilian measures. So by the late 90s, we had the coconut case against Brazil. We had 4 complaints against the Brazilian tax regime for the automobile industry. Also by the late 90s, the Brazilian industry became more competitive. And the Brazilian industry began presenting cases against barriers that they were facing now with a devaluated currency. So there was more pressure on the Brazilian administration, more attention from the Brazilian industry towards the negotiations, a more proactive behavior as opposed to the behavior in the 60s and 70s when the Brazilian industry waited for subsidies, basically, and protectionism during the import substitution policy. The Brazilian industry became more proactive in this sense. In the political history, after 30 years of military government, democracy was consolidated also by late 90s. And that situation, that change, had 2 important consequences for our topic. If you talk about the stakeholders, civil society became more organized. So NGOs became more aware of trade negotiations and the impact of trade negotiations, especially on the environmental topics. In the business community, the pro-trade discourse became more common in some associations, especially agricultural trade associations. And the democratic debate made these entities more organized and more transparent, and made the Brazilian government more transparent. On the other hand, political parties became aware of that. So what we saw in the last 2 Brazilian presidential elections was that trade was an issue. And that was only in the last 8 years. Before that, trade was an arcane, difficult topic for the public. During the last 2 campaigns, candidates presented their proposals. One of the issues was how many complaints have you presented at the WTO between the 2 main parties, for example. And so that was an electoral topic, trying to pick votes everywhere. The popular debate became widespread, especially after the Canada aircraft case. The Canada aircraft case was debated everywhere. Someone coined the term the taxi driver talk, meaning that wherever in the world you arrive and you talk to the taxi driver, you know what's the topic of the day. And many times I was in São Paulo airport and the guy was talking about the Canada aircraft, especially because after the Canada had a ban on Brazilian beef, which was very painful for the Brazilian self-esteem. Anyway, other domestic factors allied with this expansion of the political interest was the expansion of the trade community. On one hand, within the government itself, Flávio Marega probably leads one of the most prestigious departments at the Ministry of Foreign Affairs today. There was a lot of attention and a lot of interest on the department that leads the case in Brazil. This interest about trade also spread to other ministries in Brazil. The Ministry of Development, the Ministry of Agriculture, the Attorney General, the Treasury became very interested on the moves, on not only on the negotiations, but also especially about trade disputes. Along with that, law firms saw a new market on this field. Many law firms made investment on capacity building. They sent interns to Geneva and Washington for the Brazilian missions. They put pressure on these interns after they come back to bring cases. And many cases multiply in Brazil related to customs, to trade remedies, and to non-tariff barriers, also because of this pressure from law firms. The consequences of this scenario is that there is a more active participation in trade all over the country. There are political gains when you present a case. There are political gains also in the political debate. There is more involvement from the business community. There is more enthusiasm within the business community. On the other hand, as to external policy, the Brazilian attitude, this contentious or litigant attitude, is admired by many, especially neighbor countries in South America. We had an experience last year with Flávio in a meeting with other diplomats from neighbor countries discussing cases at the WTO, and the admiration towards the Brazilian behavior at the WTO was very visible. And if we take these factors, democratic participation, the participation of the business community, the participation of the trade community, we can see that the Brazilian experience may be repeated in other countries in the area. But that takes us to the second question. We have these domestic factors, but presenting cases at the WTO is an effective behavior, rationally talking, especially considering the level of compliance. We know that compliance is probably the most problematic phase at the dispute settlement process. Every WTO member asserts that they are going to comply promptly. And what we know that, especially when we need a change in domestic regulation, many barriers persist. There are known cases like the banana saga, or the softwood lumber with decades. And in the case of Brazil, we had cases like gasoline or Canada, where we can find some level of compliance after a while. Some other cases that depend on domestic legislation, especially in the US, and Flávio has talked about that, the cotton case or the frozen chicken case takes decades or years to have a minimal level of compliance. Cases are time-consuming, they are expensive, they have uncertain results. Of course, they can bring political gains, and they have a systemic relevance, especially if we think about the predictability and the respect for the trade laws. But if we concentrate on, if we focus on the economic aspects, they are not completely satisfactory in the short term. But even if they are not, the level of compliance is far from perfect. Domestic factors will explain why Brazil is probably going to present more cases. The conclusion is that Brazilians are still very gentle people. We have the historical and the social characters for that. But trade disputes will present a good example of domestic pressure that are going to explain why Brazil is going to be an active player at the dispute settlement system, even even when it faces a lot of issues at the compliance phase. Thank you very much.
Thank you very much. It was an interesting insight into the Brazilian perspective on that. I'm going to turn now to John Greenwald, longtime, very distinguished Washington trade practitioner. John?
Thank you. I have a feeling that I may be a minority of one in this room, and therefore what I'm going to say will probably not appeal to your instinctive reactions. But what I ask for is a little indulgence. And let me start with two propositions about WTO and WTO dispute settlement and enforcement that were made earlier. First, the reference to WTO dispute settlement as the crown jewel of the WTO system. Second, a reference to one of the pressing cases of our time, frozen boneless chicken cuts. Now, it would seem to me that at some point you would think maybe there's a disconnect here. And maybe, in fact, dispute settlement and all the issues that surround it are A, minor, and B, and this is the point I'd really like you all to think about, a juridical approach to dispute settlement, including compliance, in fact, is more, if I can use an aeronautic term, more drag than lift in terms of the international trading system. And let me now sort of give you the rationale, the reasons. And in doing so, I hope I shed some light on the U.S. reaction to these issues of compliance. Dispute settlement in the WTO was talked about in glowing terms as only a lawyer could. At a seminar I was at where there was a distinguished speaker from the distinguished law firm of Sidley and Austin. And he said dispute settlement is terrific. It's a great thing, but there's something I want you all in the audience to remember. And that is proof. You must be able to prove your case. The way I heard that, what it really means is you have to learn to think small. For example, if there is a systematic problem with intellectual property protection in Brazil, the dispute settlement system is not equipped to address it because it has to take each breach serially. The dispute settlement system may be geared to deal with a specific case on upland cotton, and there may be some fiddling around in the subsidies at the margin. But it is not equipped to deal with intractable problems of trade in agriculture. So let me go back to this notion that the crown jewel of the WTO system is a dispute settlement, and my response would be, if that is true, we are mistaking the tail for the dog. There are a whole series of very major trade issues that have to be dealt with, and let me just sort of go through some. How do you conclude agreements that significantly liberalize trade in agriculture without seriously eroding political support for an open international trading system? How do you persuade countries with high export-led growth, and let's put China in this category, or even Japan, that maintain a variety of significant barriers to trade? How do you persuade them to change their system? How do you strengthen the rules that govern the trade effects of product standards? How do you persuade industrialized countries, and I guess here's where I mean Japan, that remain resistant to imports of manufactured goods to open their markets? And how do you negotiate a framework for dealing with what is the sort of 800-pound gorilla in the room, structural imbalances to trade? If the answer that the panelists of the audience offer is, well, dispute settlement will take care of that, my response is, you're nuts. That is not what the system is designed to do. And it could be that what you say is, well, dispute settlement is over here, and it's self-contained and effective, and these big other issues are over here, and they're for negotiation. And that is a perfectly rational response, except that it misses two key points. What I want to do is now to, I think it was Jackson, who's the father of this rule-based system, was talking about the impact of dispute settlement, binding dispute settlement, on negotiations. And what he said is, because now dispute settlement is for real, people are going to have to pay much more attention to the language of agreements. Anybody that's negotiated internationally knows that deliberate ambiguity is the mother's milk of international agreements. And if what you do is have a system that depends on international, what I call deliberate ambiguity, to establish norms, but when in the minority of cases that those norms are tested, you have an international dispute settlement body that prescribes a reading of the agreement that major signatories don't accept. What you do is you make the negotiating process that much more difficult. I don't know that this is one of the reasons it's so difficult to bridge differences in the Doha Round, but I do know that if I was in negotiations back in the Tokyo Round, so you can absolve me from any responsibility for anything that's happened recently. But if I were in there now, the truth would be I would be very loath to agree to anything that I knew could be interpreted against me. And I'll give you an example from a real negotiating history. We were talking about the list of prohibited export subsidies. The U.S. negotiator was somebody that if you are all trade groupies, you may have come across, a guy named Gary Huffbauer. He is a very, very bright young man, or was a young man at the time. And the Canadian negotiator was a grizzled old elder statesman named Rodney Gray. And we were negotiating something that required Canada to cede. And Huffbauer, because he's so smart, wanted absolute clarity. A word was put in to make it ambiguous. The deal was about to be done, and when Gary Huffbauer explained it in his terms, and Rodney Gray said the only thing he could say, "I'm terribly sorry that you explained it that way. I wish you hadn't. We now have no deal." It is, again, the place of ambiguity is very important in international negotiations, and the dispute settlement process gets in the way. A second point of how dispute settlement affects negotiation. What you have in the WTO right now in terms of substantive rules is asymmetrical. With all due respect to Brazil, the truth of the matter is Brazil is subject to less rigorous rules, and certainly, for example, if you look at tariffs, has a higher tariff regime than, say, the United States. So it is different in terms of the degree to which they affect countries differently. China, Brazil, I would say India, would have to, if you were looking for parity in trade relationships, would have to give more than the United States would, where we have already reduced our barriers to trade substantially. The question then becomes, how does United States, Canada, an EU, let me use India as an example, persuade India to lower its tariffs to industrial products? What India can say, and does say, is we are not going to give very much. All in all, we're perfectly happy with the system we have. We can take you, United States, you, Canada, you, the EU, to dispute settlement because you use stuff like anti-dumping laws, and we have a nice set of high tariffs. Thank you very much. We're not going to move. In fact, one of the things that an Indian negotiator said to a U.S. business group was, if you think we, India, are going to reduce our tariffs to the level that you did and let China take over our market the way you have, you're smoking dope. Now, he didn't use that last phrase. He said, but you know, that was the import. So that is another way in which this fondness of rigid dispute settlement gets in the way. Next is the issue of the political climate at home, the need to have outlets in the system. I mean, I wish I could tell you, because I feel strongly about it, that the Byrd Amendment in the great scheme of things really matters. It doesn't. I wish I could say, because again I feel strongly about it, that zeroing really, really matters. I mean, it matters in anti-dumping cases, but this is such a tiny fraction of trade flows that it is almost inconsequential. The reason these things matter is that they let off some of the pressure for commitment, broader commitment to a liberalized trading system, and that is terribly important. And this is where I'm going to close. If there were not a crisis looming in the international trading system, you know, the fact of the matter is, I would say what I am saying is not really of great consequence, and the fact nothing this panel is going to say is of particularly great consequence. It just is too small. The issues are too small to matter. But the fact of the matter is, if you paid attention to the newspaper, we are now running a trade deficit that is close to 6% of our GNP. Does anybody have the notion of a GNP of Brazil? Roughly 3 trillion, so 700 and some odd, it's about a fourth. 1 trillion for you? All right, well, we have, our deficit is essentially equivalent to your GNP, is that right? 700 and some odd million. I mean, it is a staggering proportion. There is going to have to be some sort of accommodation, because I don't believe the system will work short of a radical devaluation sooner or later, and probably sooner, of the currency. The question then will become, what happens? Where, if the United States dollar devalues, are you going to start, is Brazil, I'll put this all of the Brazilians in the room, are you going to start shipping your, the regional aircraft to Japan? To China? Where is your market? I don't think there's a tendency to look at dispute settlement in this broader context. But because it's so rigid, and because the speakers here want to make it even more rigid and more automatic, I fear that it will get in the way of releasing pressure, which I suspect is irresistible over time from the system. That's the essence of what I wanted to say. I would be happy to talk about any particular WTO decision, like on Byrd, which Mr. Backus may have wrote, and which I would, I think is an atrocious decision. But that's for another debate. What drives the United States here actually is, in a very funny way, I think, an understanding that an international system has to work, but that if you impose too many rigidities on it, and that's not the way the GATT was designed. This all sort of stems from the GATT system, which is a contract where it's mutually beneficial. If you try and make it too rigid, if you try and make it too legalistic, you're going to put the whole system in jeopardy.
Well, thank you, John. That will certainly provide food for a good discussion when we finish. Our next presenter is Jim Backus, who was a member of the WTO appellate body and therefore highly qualified to speak on this panel. Thank you, Jim.
But largely forbidden to do so. Despite what Ralph Nader has told you, there are WTO rules of conduct, and they forbid me from explaining myself or from defending myself when I'm summoned to do so. Generally speaking, I feel little need to defend myself anyway. But I'll try to be as specific as I can be, both in responding to some of the points that have been made and also in responding to your questions. But please keep in mind that with the, I think, sole exception of the cotton case, with which I had nothing whatsoever to do, I did write just about all of those opinions, along with my colleagues. So I share in the blame for that. Let me thank my friends from Brazil for inviting me here. I have to say I have yet to meet a general Brazilian in Geneva. The aggressiveness of Brazil as a member of the WTO is very much to the credit of the government of Brazil and the people of Brazil. Brazilians assert their rights, and Brazilians try to look to the global interests of the entire trading system, and I applaud them for that. Let me also say a word of thanks to my friend John Greenwald. I think it was John and Bob Cassidy in 1979 who came into my office shortly after I arrived at USTR as a political appointee from Florida and handed me a copy of something called the GATT. So it's John's fault in large measure if I've gone astray along the way, because in addition to that, he contributed generously to my various political campaigns. Like most of my longtime friends, he profits considerably now from the fact that I'm no longer pursuing political campaigns. Let me step back a minute and say a few words about the dispute settlement system generally, because I am free to do so. And then, if I can, I'd like in particular to address some of the points that Flavio made, and especially that John made. And John may be surprised to hear that I agree with much of what he said. First of all, I think it's important for all of us to recall the purpose of the dispute settlement system. The purpose of the dispute settlement system is not to render legal rulings. The purpose of the dispute settlement system is not to develop a broad corpus of jurisprudence or quasi-jurisprudence, if you will, although the system has certainly done so in the past dozen years. I believe there are now 30,000 pages of rulings and recommendations in dispute settlement. The purpose of the dispute settlement system is to resolve disputes. This is what the dispute settlement understanding says. This is what the members said in their dispute settlement understanding, and this is what the appellate body has said in echoing the members of the WTO. So the question is, what does it take to resolve a dispute? Dispute settlement, formal dispute settlement, the request for consultations, the request for the establishment of a panel ruling, an appeal to the appellate body, and a ruling by the appellate body. An adoption of a panel report is amended by the appellate body report by the DSB. All of these are tools to be used in resolving disputes, but they're only tools, and they are not by any means the only tools that are available or should be available. What happens out in the world every day? Well, those 30,000 pages of rulings are intended to clarify, to the extent that they can, about 30,000 pages of rules on which the members of the WTO have agreed, ambiguous or not. These rules are enforced. They're part of the WTO treaty. There are a couple of dozen different international agreements that comprise that treaty, plus all the schedules of all the WTO members, extending to thousands of pages. And on any given day out in the world economy, every member of the WTO, and now it's 150 countries and other customs territories, does their best to comply with all of these rules, and generally does so, and increasingly does so. And I think there are many reasons for that. Foremost is the fact that most of these rules make sense, are widely agreed. Beyond that, there is the fact that most countries generally want to comply with their international obligations, especially when they make sense. And I think that's true of the United States and Brazil. But also, I think there is behind the curtain of their consciousness and awareness that there is a system in place to uphold those rules if they don't comply with them. And I think that's made a difference over the past dozen years. The fact that we have rules that are agreed and can also be upheld through a process of dispute settlement is, I think, of value in the day-to-day doings of world commerce. I made this point to my son, who is 26 now, John, and is a journalist, And he said in a journalistic fashion, "Dad, that's not news." And it's not news. It's not anything anyone's going to report. If there's a journalist out there writing, I know you're not going to report this. I was a journalist myself. It's not news. But it may be the most important fact to know about the world trading system and about dispute settlement. Also, it's important to know that the vast majority of what might become legal disputes between and among WTO members are resolved without there ever being even the first inkling of any formal dispute settlement. The mere fact that there is a system in place gives WTO members the ability to say to other members, by the way, did you know you have an obligation here? Many times they don't realize it. There are a lot of pages. And did you know that you must comply with this obligation? And probably they don't even say the next sentence, which is, and if you don't, we might have to take some action about it. I've been involved since leaving Geneva in a number of instances where by simply pointing out the existence and the nature of an obligation, a potential dispute has been resolved. It's never even risen to the level of journalism. It's never even crystallized to the point where it might even be defined as a dispute. It's resolved without there needing any means of formal resolution. And this, too, is a value in the system. And this, too, I think, happens every day. And although it's not news, it's significant. It is important to members of the WTO and to the system. And I think that the fact of the dispute settlement system enhances this particular aspect of day-to-day trade. But then, of course, oftentimes the issues are intractable to the extent that one country has to seek that first step in dispute settlement, which is to request consultations. You file a piece of paper in Geneva requesting consultations and setting out briefly the substance of what the dispute is about. This happens every day. And in the vast majority, and there are numbers that are published by the WTO to demonstrate this, and in the majority of these consultations, the dispute is resolved as a result of consultations. And it never goes beyond that. The consultations lead to a resolution of the dispute. And I think the fact that the consultations could lead elsewhere to a formal legal form of litigation enhances the ability of members to resolve these particular issues in consultations. But of course, there are many disputes that are not resolved in consultations, and so that first legal step is taken through the filing of a request for the establishment of a panel. A panel is convened, and the members who are party to the dispute then proceed to a judgment in the dispute settlement system through a legal process. And it's important to realize that from the time the request for the establishment of a panel is filed until the adoption, until the issuing of the appellate body report on a possible appeal, it is purely a legal process. Parties are free to resolve the dispute through negotiations and end it, and sometimes that happens. India once canceled an appeal on the day of the hearing, and that was fine. The dispute was resolved. But it is a legal process that then occurs. And when the panel report, as amended by the appellate body report, is then adopted by the dispute settlement body, I think it's important for us to acknowledge that in almost all of the cases that have come to the dispute settlement system in the first dozen years, that particular dispute has been resolved in what the parties to the dispute agreed in WTO terms was a positive solution. So we are left then with, at any given time, a handful of cases. And Flavio mentioned some of them. And some disputes are hard to resolve and harder to resolve than others. And I think it can be argued that some cases that have come to the WTO should never have been brought to the WTO. I mean, my job on the appellate body was not to tell parties that, again, in WTO terms, it wasn't fruitful to bring a particular dispute. Maybe I thought the United States should have brought the bananas case, and maybe I didn't. But my job was to render a legal ruling once legal issues were raised on appeal, and it was a given that there was such a dispute and that a legal ruling was needed. But in other places, in other guises, in other roles I might have had along the way, back when I was in the Congress of the United States, I might have raised my hand in a particular instance and said, is it really best that we try to resolve this particular dispute through litigation in Geneva, or is it better to resolve it in some other way? I have no role right now, for example, of any kind in the Boeing-Airbus dispute. For the record, I have absolutely no personal view on the merits of that dispute, nor have I ever expressed one. But I will say here what I've said in Europe, which is I believe that the members of the WTO who are parties to that dispute have better things to do than resolve that dispute in dispute settlement, and that particular dispute can and ought to be resolved through a resolution between the two parties bilaterally. That particular product is one that only those two members make. The rest of the world may or may not want to see what rulings come out of a WTO decision in the Boeing-Airbus dispute. And Europe and the United States may not want to see those rulings either. That is, in my view, a good example of the kind of dispute that ought to be resolved bilaterally through a negotiated settlement from the parties. But it's also important to realize that the way the system works in Geneva, if this proceeds through a panel and if the appellate body renders a ruling, it won't be because the appellate body wants to do so. It will be because the appellate body must do so under the WTO rules. Frequently, my former colleagues on the Hill have asked, why in the world did the appellate body see the need to rule on this issue? It's because a particular issue was raised on appeal, and the DSU requires that the appellate body in some fashion address every legal issue that's raised on appeal. Period. There's no discretionary jurisdiction, unlike the Supreme Court of the United States. Now, my friend Mike Moore did indeed describe the dispute settlement system as the crown jewel of the system, and that's a nice compliment, but we need to ask why he would say that. Well, first of all, I think he was proud that the dispute settlement system was working. But second, I think it stood out at the time because nothing else seemed to be working. Those of us who helped establish the WTO hoped and believed and thought, and I was one of the half-dozen original co-sponsors of the implementing legislation for the Uruguay Round trade agreements in the House. We hoped and thought and believed that the WTO would be an ongoing forum for concluding new agreements. We believed, yes, in the need for rules to guide world trade, and we believed in upholding the rule of law in world trade. But we thought it best, and by far preferable, that disputes over what ought to happen in world trade ought to be resolved through negotiations by making new rules or clarifying existing rules. In other words, it ought to be done by the members themselves. Dispute settlement is and ought to be a last resort. And I should add, in terms of compliance, we focus on suspension of concessions in many of our discussions in our arcane, esoteric debates. But the dispute settlement understanding itself says that suspension of concessions should be a last resort. So that's way down the track of last resort. Back in 1995 and 1996, we hoped, yes, that dispute settlement would succeed, but we also hoped that the WTO more broadly would succeed by being a forum for concluding new agreements. It has not succeeded nearly to the extent that it should in making new rules or in revising existing rules. And one of my great fears is that the entire system will be endangered if too many issues are left to resolution in dispute settlement. I believe the system is unbalanced, and I believe it is incumbent upon the members of the WTO to right that balance by focusing anew on the important task of negotiating on a multilateral basis to strengthen the multilateral trading system. For example, I believe it's a mistake to divert too much attention and too much negotiating effort to free trade agreements. If I were still in the Congress, I would vote for all of those that are pending on the Hill right now. That's not my point. My point is there's a limited amount of political energy, a limited amount of political capital, a limited amount of opportunity, and we ought to be focusing on where we can derive the best and most in the way of results through global trade liberalization, and that's through global agreements. So I certainly agree with John that we need to look at dispute settlement within the broader context. One final observation, and that would be about compliance itself. I won't be second-guessing the agenda of the next DSB meeting, but I think it can be said truthfully that the United States has, by and large, complied with WTO rulings, and it would be a mistake just to single out a few because as a major disputant in the WTO, because it is a major trader in the trading system, the United States has been involved in many disputes. I do believe that it is incumbent upon all WTO members to try their best to comply with rulings in dispute settlement, to set an example for others, and because, in particular in the case of the United States, I think separate and apart from our particular interest in any particular dispute, the overriding American interest is in the success of the global system. That's in our self-interest because we are such a large trading country. But I do think it's important to emphasize that the members of the WTO are and remain sovereign states. No one of them is bound under the WTO treaty to comply with any WTO ruling. Each one of them has a sovereign choice to make. Although, in my view, the choice should ideally be to comply with a ruling, nevertheless, we need to respect the right of sovereign countries to choose not to comply with rulings, and to choose also to take a reasonable period of time in doing so. I think that's all I have to say for now. Thank you.
Thank you.
Oh, one more word. I wanted to thank Flavio for reading my book.
With pleasure.
I haven't been able to get my law partners to do that. It's considered non-billable time.
Well, I think we've had a good exposition here of one of the time-honored continuum in the whole question of international trade at the multilateral level here today. It's interesting. As I was preparing to moderate this panel, I pulled out my copy of the Dispute Settlement Understanding and referred to Article 3.7, which is one of my favorite articles. But it actually is, I think, the one reflection of one poll in this debate, which Jim Bacchus just referred to. It begins by saying that before bringing a case, a member shall exercise its judgment as to whether action taken under these procedures would be fruitful. And I think we've seen some of that debate here today. I guess what I would like to ask the members of the panel to share some thoughts with you on is whether the sanctions, if you want to call them that, are subsequently outlined in that same Article 3.7 are really the right sanctions for a multilateral regime that is supposed to support a liberal trading regime. Because, as was alluded to in the presentations, the aim of this mechanism is to secure not just a solution of a dispute, but the adjective positive appears before solution. So the aim of this whole mechanism is to secure positive solutions to disputes. And then, of course, if mutually agreed solutions can't be reached, the hierarchy is that you seek withdrawal of the measure, then you can seek compensation, and then finally you can withdraw benefits. But if everybody is interested in a liberal trading regime and really believes in the rules of comparative advantage, what is the ultimate benefit of withdrawal of concessions and so forth? So I'd ask the panel members to reflect on some of these apparent contradictions, perhaps. Bobby, do you want to start us out?
Yes, thank you, Whitney. Before we go to the aspect you've raised, which I think it's very important, because as Jim Backus mentioned, at the end of the process, so to say, the countries always have the option to adopt countermeasures, that is, to adopt retaliation, which means, as you mentioned, withdrawal of benefits. I would like to comment, as you said, John gave some food for thought. I would like to give some thought, provided he has given the food. Basically, John made his presentation 2 points. One, that the DSU, the Dispute Settlement Understanding, and the DSB creates somehow a rigidity to the system, and especially to the world trading system. And the second aspect I note from his presentation is that the importance of the DSB is very limited if we compare relative to the importance of the size of the world trade and the day-by-day trade as it happens. I could not disagree with that point, but at the same time, I would like to point out that the fact that we have rules and the fact that, especially as in the case of Brazil, as Felber mentioned, a country that responds for a little more than 1% of the world trade, it is very important to know that you have the option to go to a dispute settlement when you find a country is not abiding by the WTO rules. And if we take, the chickens, the frozen chicken cut case, we have also a very good article by Jim Backus, which is in his book about the death of Sir Francis Bacon, and he makes a relation with the case of frozen chicken cuts. That may be small if comparable to the world size of to the size of the world trade, but that was very, very important for Brazilian chicken producers who were increasing year by year the exports of frozen chicken to the European Union. The volume of trade in the last year of exports was more than $350 million, so it's not an amount that it's not important. And the fact that we won the case shows that you can go to the WTO and say to the European Union, you cannot unilaterally change your tariff line and start to apply a tariff that before was 15.4% to a specific duty that became more than 70%. So yes, it is relatively small comparing to the size of the world trade, but it is very important for Brazil, and it was very, very important for the producers of chicken in Brazil who were increasing the market in the European Union. If we take the cotton case there, the importance is even higher, if we could so say. First of all, as you all know, the panel discussed the main issue of the peace clause. The United States basically said, Brazil, you cannot bring this case to the WTO because I have the peace clause, which guarantees me that for 9 years, subsidies to agriculture will not be subject of challenge. So it was a very important discussion that finally gave reason to Brazil that the peace clause had ended. And therefore, not only Brazil, but other countries could challenge subsidies to agriculture in the WTO. And with regard to the subsidies itself, which were the other part of the dispute, besides the concrete results that it will bring and is bringing to Brazilian cotton producers and exporters, it was a very important learning process of how this complex subsidy system works, for instance, in the United States. It is a very, very complex system that has been put in place for decades, and the fact that one developing country like Brazil is able to take the case to the WTO and to show that the prohibited subsidies and the actional subsidies were illegal by the WTO legislation is very important. And also, in my opinion, it helped a lot in the Doha negotiations because it made crystal clear the size of the subsidies, for instance, that the U.S. grants in terms of domestic support for its agricultural and especially cotton producers. If we take the sugar case, the sugar case is also very emblematic. We have there, after the results, we don't have yet studies showing there is a correlation between the decision of the WTO, that is the European Union, which was before exporting around 5-6 million tons of sugar yearly, has to abide by the levels, subsidized sugar, has to abide by the level bound in the WTO, which is 1,295,000 tons. The price of sugar has doubled since that. So once again, we have very concrete results for not only for Brazilian producers, but for competitive producers of sugar worldwide. So not trying to disagree with your point of view that the dispute settlement has a relatively small participation when you take the world trade volume as a whole, it has a very important, it is very important because we are assured that in case there is violation, we have some place where to resource and to try to make Brazil's rights and other WTO member rights valid.
Yes, John, please go ahead.
I was active in negotiating way back in the late 70s and the early 80s, and the truth was, of all the delegations in Geneva, the Brazilians per capita were the best. We tried to overwhelm them with numbers, but in terms of their ability to present Brazil's case, they were very good. And by this intervention, you can see they still are. Now, what I would like to do would be to take the other side of that. I mean, what you have had right now is a presentation saying Brazil had very concrete interests and was right to bring them before a dispute settlement panel and have them adjudicated. And my reaction to that is that's absolutely right. And writ small, that's what the WTO is designed to do. In fact, the WTO is designed precisely to deal with a bigger issue where we're involved on the Boeing side, the Boeing-Airbus dispute. But let me now give you the U.S. response.
I didn't know that.
Well, there you are. I was at a meeting before coming here on that very issue. Let me give you a U.S. response to put into context. It is no doubt true that Brazil has a major interest in cotton markets where we are sort of a presence. Soybeans, sugar, lots of oranges, clearly. So there are a lot of very well-defined interests. On the other hand, it is equally true, for example, that the U.S. has a very big interest in information technology access to the Brazilian market. And what's going on now is a U.S. effort, and it isn't only with Brazil, it's also with India, it's also with China, to persuade through negotiation the Brazilians to open more than I think instinctively they would like to do. The question becomes one of negotiating leverage. It goes back to how the dispute settlement process relates to the system. If Brazil can beat us on oranges, soybeans, sugar, whatever, through negotiation, through the dispute settlement process, and we say, yeah, but what about IT? And they say, wait a minute, you don't have justiciable claims against us in dispute settlement on that, so forget it. You really do leave countries like the United States with no option but to say, ultimately, in order to bring a balance, and don't forget that the WTO is ultimately about economic balance. In order to have this balance, you can win your case on cotton. But you're going to have to take, and this goes to your point, Whitney, you're going to have to take retaliation, because as things now stand, we are not going to do what you want, given the imbalances and the asymmetry that exist in the distribution of obligations across countries and across areas.
Okay. I think Jim wants to jump in on this, and then I have a question for Wilbur.
Oh, there is an alternative, and the alternative is to negotiate. Let me use agriculture as an example. Brazil has brought and won the cotton case against the United States, and we're in the process of a period of implementation on which I will not opine. But there are other products produced agriculturally by the United States and produced also by Brazil and other agricultural producers worldwide. The Congress of the United States, my friend Colin Peterson and others on the House Agriculture Committee, their counterparts in the Senate, are in the process now of working on a farm bill for the next number of years, in which they have to set an overall level of subsidies. Now, it may be that they have a choice. The Canadians brought a case a couple of weeks ago on corn that I think highlights this choice, and I think 35 other countries have now signed up as third parties in support of the Canadians. The United States can set its level of subsidies in the Farm Bill independent of anything that's happening globally in trade negotiations or in dispute settlement. And there may be a series of cases, hypothetically, on not just cotton and corn, but other products. And the United States, hypothetically, might lose a whole series of cases, in which case the United States would confront not just the situation it confronts now in cotton, but other situations as well, in which it may have to cut its subsidies as a consequence of dispute settlement, but, as John pointed out, won't get anything in return. Or the Congress can decide that we're going to negotiate with other countries now in the Doha Development Round on some cuts in our subsidies in advance of any possible dispute settlement that might be pending or threatened, resolve those issues through negotiations, and get something in return for the concession we make on agricultural subsidies, whether it's in information technology, other forms of non-agricultural market access, or whatever. That's a concrete example of what I was talking about needs to be done in a broader context, and why I think it's important that whoever they may be, members of the WTO, focus again and anew on the need to negotiate a resolution of their existing and potential disputes through the global negotiations.
Thank you. Wilbur, I was interested to hear your explanation about some of the background to dispute settlement and its evolution in Brazil. And I hearken back to my own experience. I think it was in 1988 when Brazil was faced with pharmaceutical 301 sanctions and did a real Hamlet act about whether to initiate dispute settlement against the United States. Of course, that was under the old GATT system where dispute settlement was non-binding. After visitation by Professor Jackson and so forth, Brazil was finally convinced that no, it's not a big problem to bring a case against the United States. It's not a sin, and you're not going to be sentenced to perdition. And Brazil did request consultations, and lo and behold, something got worked out. Probably because it was a dagger pointed right at the heart of 301, and the United States didn't want to confront that. But does it really make a difference now that dispute settlement is really binding, or as has been suggested by John, is negotiation still a possibility?
Well, thanks for the question. Before going into that, I'd like to react to John's provocation on one specific point. He mentioned constructive ambiguity. It's a known phrase in the GATT years that if you had the United States and Europe, and someone was saying that that is black, and the other side was saying that is white, they would just put it's not colorful, and someone would have to interpret that later. The problem with this constructive ambiguity is that it's a source for disputes, and there's some contradiction between a strong dispute settlement system and ambiguity in international trade laws. And the main problem with that is someone at the very end, a panel or the appellate body, will have to say how dark the thing is. And when the panel does that, the United States is going to say that it's judicial activism because obligations were created. But the original sin, going back to our religious terms today, is constructive ambiguity. So there is some contradiction at this level, just to provoke you. The other thing that Whitner mentioned, and taking into account the Brazilian experience, is how rational are the suspension of concessions, the retaliation into the cases. And we have to consider that at the multilateral, the retaliation is regulated at the multilateral level, but it's conducted at the domestic level. And at the domestic level, we have incentives for not complying at the losing member, and to impose sanctions at the winning member. In both cases, we may have political gains. I remember the Canada case when Brazil won the Canada 3, the aircraft 3 case, and there was this spirit of revenge in Brazil. We are going to impose sanctions on them now. And this situation becomes even more problematic in cases when we may have cross-retaliation, when retaliation may be taken to intellectual property or other situations. So going specifically into your question, when these topics were conducted in Brazil by bureaucrats, this idea of guilty, a very Catholic idea of guilty, was more present. Now you have to consider all the parties that are involved. And in many cases, the Brazilian industry, some parts of the Brazilian industry, may be benefited from the imposition of sanctions, and they may create some pressure for that. So there must be some level of optimism when sanctions are imposed. It's a very complex scenario. If you can see, like in a country like Brazil that is not as well organized and not as well transparent as it is here in the United States, that you see some moves from both sides. People who want the sanctions to be imposed as a way of preserving their domestic market. People who are going to be affected by the imposition of tariffs, for example, on industrial equipment, on their industries. So it's a complex situation, and sometimes there may be advantages on imposing sanctions for specific industries. So being or not, and just for the record, there is some discussion about buying out the compliance, meaning that Professor Jackson has a very interesting article where he states that you cannot buy out the right not to comply. You have to comply. the imposition of retaliation is a temporary measure. The final obligation, which was defined, although, of course, John is going to say that it's esoterical. Yes, but it's the final obligation that is stated there, although not completely realistic, is compliance. But the imposition of sanctions, yes, may have some advantages in both domestic markets who are involved.
Well, perhaps Brazil is a big enough trader that the traffic ticket theory of compliance won't apply to Brazil. I mean, maybe it would apply to Anguilla or someone like that, but not to Brazil. Are we? Yes, please.
The question that an agreement is rigid or not, certainly will have some impact in the amount of controversies or litigations we may have over this agreement. It's clear, maybe we have less litigation. If it's ambiguous, even if it's constructive ambiguity, you may have more litigation. The fact that the agreement we have at WTO, it certainly has motivated much more litigations or disputes than the ones that is being submitted to the dispute settlement system. And so the question that I put to myself, why? So if they are not being settled under the dispute settlement system, they are being settled otherwise. Like you mentioned, this claim opposing basically to big corporations. Of course, they prefer to settle in other fora. But why we are having frozen chicken bones, sugar cane, and this kind of agriculture products being handled at the dispute settlement? Probably because the issues there, or the plaintiffs there, they are not as organized, or they don't have this other fora to complain. I mean, since the 17th century, the trades, the players of the trades are not state companies or between companies, but are private companies or big corporations and exporters and so on. The exception is the commodities. If I'm a producer of coffee in Brazil, can you imagine submitting to an international private arbitration under ICC, or even engaging a direct negotiations to solve a problem that is opposing me to my coffee roaster here in the U.S.? Most certainly not. So the chicken frozen cases are very important, not because in terms of amount, because it guarantees an access to a dispute system that otherwise is not available for this kind of trade players.
I think we get to a question rather than just a speech. I know we've done a lot of talking up here at the panel, but
interesting point, though.
It's a fair point. It's a fair point.
Is that so? It's not a question of focus.
Well, I mean, what it seems to me you have is a system that is well suited to dealing with chicken bone cases or boneless chicken cases, I guess, or big things like Boeing Airbus chicken cuts. I mean, it works. It does work. And I really do not mean to underestimate its importance in the context of that dispute. To Boeing, the Boeing Airbus dispute is a really, really big deal. The point I want to make isn't that that doesn't work. But it goes back to your question on what do you do about ambiguities? What price do you pay if the system is so rigid that you submit disputes, you take a Jacksonian and John Jacksonian view of the world, compliance is required, and you have a legal system. The price you pay is one, nobody's ever going to negotiate an ambiguous agreement again. And that means your negotiating abilities are reduced. Second, those countries that have less obligations in this distribution of global trade obligations will resist granting any new concessions and instead will rely on their relatively preferred position. So really all I'm saying is you have to understand at some level that the way this system works is based on perceptions of balance globally. And that's why I talked about our deficit in the end. And you, in that context, you have to understand what is legally true. That is, if the United States loses a cotton case, it has a sovereign right to say, we're not going to change. You go retaliate, we're not going to grant compensation. The system is structured so if you think you're being injured, you take action. Because as the system now operates, we don't see the balance. And at some level, and this is sort of the final point, and I realize I'm going on this theme too often, but I do think it's critical. At some point, if we continue to have near $1 trillion trade deficits, and if the pressures internally grow to the point that we, as a, sort of a matter of politics, forget the economics, decide we cannot continue, then what happens? It seems to me that is an enormous price to pay. And it strikes me that when I talk about the rigidities of the system, it's that's the end result I see sooner or later.
So there I think
Very
we've had the
practical
be careful what you wish for theory of international trade.
Right, that's right.
So I think Flavio has a plane to catch, so we probably need to conclude this session. But I want to thank each of the speakers. I think it's been enlightening and entertaining as well. Thank you.
Thank you very much.